Alex here with part 3 of the My Docket series on child custody and visitation. I'd like to take this opportunity to direct my viewers to part 0 of the My Docket series, as that is the video that contains the detailed disclaimers and the purpose of the series. A couple of things that I want to go over, even if you don't check that video out, is number one, don't feel bad for me. My case is completely and totally over. It's closed. My ex's parental rights were terminated. It cannot be reopened. I'm not in the middle of this right now. Number two, the purpose of this series is to provide my viewers with one big, gigantic example as to how I represented myself, for the most part, against my ex, who had an attorney, for the most part, over the course of an 8-year-long high-conflict child custody ordeal. That being said, in part 2, I covered my ex's ex parte filings, what amounted to a counterattack in response to my filing of the petition for child custody and visitation in part 1. The petition that she filed, alleging that I was a violent and dangerous person, was done so in secret. That's how the ex parte process works. So I am aware of it now in hindsight, and I'm covering it in this series, but try to keep in mind that at the time, I had no idea that she had filed this. I was not served with a copy of it, and she was able to go and have a what they call a temporary order of protection issued without my ability to participate in the hearing, without my ability to respond and controvert her allegations, and without my ability to cross-examine her. And all of this is because you just aren't even aware at this part of the process that your ex has even done anything. You don't find out until it's all been said and done and the order for protection has been granted. So keep in mind that while I'm going over this now and I'm trying to explain the process to my viewers, I at the time had no clue that this was occurring. So this is an interesting video because when I reviewed the docket in preparation for the series, I discovered that there was a hearing on this particular day. I did not know this until I started to work on the My Docket series. So I was very curious as to see what my ex stated at this hearing, since I wasn't there. I wasn't served. I was not invited to participate in this hearing. It was just supposed to be her and the domestic master. If you want to know what a domestic master is, please watch my video on domestic masters. It's kind of like a judge, but they're not elected. They're hired, and typically they enter recommendations for orders, which are, I'm not going to say easier. What I'm going to say is the process to challenge them is different from an ordinary appeal, and I cover that in the video, Objections to Master's Recommendations. So, as I mentioned, this is how it's supposed to work. She's supposed to go to a hearing, and she's supposed to speak to the domestic master and convince them that under the law, or convince her that under the law she's entitled to an order of protection, a temporary order of protection. When I watched the video, I almost thought the clerks gave me the wrong one. I continued to watch it because I just couldn't see her. She wasn't, at the hearing. And I was about to give up when I noticed a very short portion of the video where a worker walked in to the judge's office. And by the way, you're going to get to actually see this this hearing, the hearing video in a moment. Anyway, it's interesting. It's not like in a courtroom. It's like each of the applicants goes into the office of the domestic master, and they just sit across from her desk and just talk to her. Anyway, throughout this video, applicants are coming and going. They're talking to the domestic master. They are issuing orders of protection. I didn't watch them very carefully because I was just looking for the one that contained my ex. And as I mentioned, I couldn't find her. And then finally, I heard her name mentioned at this one portion of the video that was very quick. And apparently, my ex did not go in and speak to the domestic master. It was a worker, like a staff member, that walked in and told the judge she needed a signature on the order of protection. So what I did was look into the rest of the video to see if there was any other examples of this occurring. And there probably are around between 13 and 15 applicants, and none of them do that. All of them walk in, all of them sit down across from the domestic master, and all of them testify, and they are either granted or denied the request for an order of protection, a temporary order of protection. My ex was the only one that just refused to go in, and a staff worker walked in and had the judge sign the order, just like that. I looked into the law, the statutes, and I also looked into some of the court rules, and it appears that this is perfectly legal. From what I have read, the only thing that is required, that is mandatory, is that the applicant file an application supported by an affidavit under penalty of perjury. And she did. And what appears to have occurred is that she requested for her application to be considered on the paper alone. She didn't want to go in and sit down and communicate to the domestic master. Having reviewed her filings based on the law, it appears to me that there is enough there for a judge to grant a temporary order of protection. They don't actually have to prove that you've done anything. And to get a temporary order, you don't actually have to have an evidentiary hearing. You can just do it based on allegations alone, what they call a prima facie case. So, having read the court rules, I was satisfied that there wasn't anything illegal going on. It was something that they were allowed to do. There are references in the court rules and statutes about requiring a applicant to appear at a hearing and testify, and from what I read, the language is permissive in both areas, in the court rule and in the statute. So the court or the domestic master may require an applicant to testify, but they don't have to. So I'm pretty satisfied that what my ex did, while unusual, was perfectly legal. And if you have any questions on why that's, like any more detailed questions on why that's okay, please watch my video on temporary orders. So going forward, let's take a look at this curious and short hearing.
Sorry. Is Martha still in LA? Yeah. Can you talk to her? Because I know you're a bit slow over there. Thank you. Thank you.
So as you can see, not much of a hearing. There basically was no hearing. And had I not paid careful attention, I would have done this video and told my viewers that something's wrong. Maybe the video got deleted and it wasn't recorded. But the staff worker mentions her name, by name, that there is an order that needs to be signed in the Farrar case. And the domestic master signs it. That's it. Beginning, end. And I'm sure some viewers will find this a little shocking because it just looks weird for a specific person to be treated differently than everyone else. But the law doesn't see it that way. Under the law, you don't have to do something the way everyone else is doing it. And if you review the actual order of the application for order of protection that she filed in Part 2, you'll see that her allegations are sufficient to justify the temporary order, not the extended one. You can't get an extended one unless your opponent is actually served and has an opportunity to appear in court, controvert your testimony, and cross-examine. And that does occur later on. The hearing does eventually come, and you will get to see me appear and contest all of this at the extended protection order hearing. But at the temporary protection order hearing, you don't have to prove anything. You just have to make certain allegations, and if you've done that, whether it's in writing or whether you've done it verbally in front of the domestic master, if you've done that to the satisfaction of the law and of the opinion of the domestic master, then you are entitled to a temporary order of protection. Moving on, you can see here we have the protection order worksheet. This looks like a single-page document that either an employee or the judge themselves scribbles in some details as to the proceeding itself. I'm talking about the order of protection proceeding and also any other proceedings that are pending. I say that because I can see here that they're listing the actual child custody action in this worksheet. Nothing really jumps out at me that needs to be covered with regards to my viewers. They check the little granted box here for the temporary protection order, and the notes that they take are all consistent with the application that she filed, which I covered in detail in part 2 of the My Docket series. So you'll get a much better analysis from me if you want to actually take a look at part 2. So let's move on to the next document, which is the temporary order for protection against domestic violence. This is actually the first court order that I encounter that actually imposes some kind of restriction on a party, and in this case it's me. The other order that I believe I covered in the previous video was just scheduling a hearing, and I may actually be wrong about that. I don't think I covered that yet. Yeah, that gets covered in this video actually. So this is actually the first court order in my entire child custody and visitation experience, and sadly enough, it's a order of protection. So let's move on. This is a form order, so there isn't going to be a whole lot for me to cover for the viewers. Form orders are like mass-produced, fill in the blank, mark the check boxes types of orders. They don't use them very often. They typically use them in proceedings that are filed by the thousands. And so I'm just going to point out what really jumps out at me. First off, you can see the date that this is issued and expires in the upper right. If this isn't served in time, this temporary order for protection, there are actually statutes that allow the judge to extend it repeatedly. I know that they can extend it at least 3 times, and what I mean by that is not so much that they'll issue an extended order of protection. They can't actually do that unless you're served and appear in open court, but they can extend the duration of the temporary order. And so it makes me kind of wonder why they even bother forcing the court to jump through all those extra hoops. They may as well just give the court the maximum amount of time straight from the get-go. The first box is the one that warns the adverse party that they're going to be arrested if they violate the order. Looks like the first line cautions, or at least notifies the party, that an application and affidavit was filed in the court. It was, and that this order was issued against you. The next portion of the order details what you are prohibited from doing. I mean, you guys could really read this for yourself. If you look down in the description below, you will see the links to these papers. But everyone pretty much knows how these work. You're not allowed to go within certain distances of like workplaces, of residence, the applicant's residence. And unless something jumps out at me, I'm going to just move on. This is interesting. They will prohibit the adverse party from interfering with the applicant's custody of the children. Oh, but this appears to be something with regards to disparaging comments. For a second there, I thought that this could be used to interfere with a person's custodial rights, but that's not exactly what they're saying. They're talking about disparaging the children. They're asking, or they're ordering that I stay away from the child's daycare, which is a confidential address. So it's like, okay, stay away from a place that you don't know where it is. There's the workplace. Here is the portion of the order that notifies you as to when the extension hearing shall be held. I heard that this doesn't actually occur for all types of protective orders. There are other types of protective orders that people can get from like the justice courts. And apparently, to get an extension, you actually have to ask. Like they'll issue the temporary order, but they won't issue the extension unless you request it. Well, with orders of protection against domestic violence, it's just built in. The extension hearing gets just stuffed into the order itself. Here's the order to law enforcement. This just tells police officers you must arrest this person if they are in violation of the order. Oh my God, this is sad. This is the portion that I hear about. This last sentence here is the one that allows, actually, it orders, it imposes a duty upon the police to remove the adverse party from their home. I'm glad that that didn't happen to me. Talk about violating someone. Now, I know people are going to say, well, yeah, they're an abuser, but how do you know? Because these orders are issued on accusations alone. You don't actually have to prove abuse. And in my case, my ex didn't even talk to the judge. If you looked at that hearing video, they just did it based on the application and the affidavit. Didn't even see her. I don't know. The things that we allow as a society. It's not that people should be forced to put up with abusers. The problem is, how do you know it's being used against abusers? That's the problem. Somebody could just claim that their ex is one without it actually being true. Okay, all fees are deferred. This is something that I read in the statutes. Apparently, the court defers all fees at the onset of proceedings and may impose fees at the end of the proceedings, but it's discretionary. The judge can reduce the fees or outright waive them. In my case, I never had to pay any fees, so maybe they just routinely defer the fees and then routinely waive the fees at the end. If anyone here has actually had to pay court costs or filing fees in a protection order hearing, like at the end of the hearing, definitely let me know, because I always assumed that they were free under the law, but apparently they are deferred under the law, and then the court may, at their discretion, waive the fees if they want to. Here's a signature from Linda Gardner. She's the domestic master. They also call them court masters and hearing masters. Oh, I wish they would put this on all court orders. This notice here that requires you to keep the court informed as to your current address at all times. They really should put that on all court orders. I can't tell you how many people have contacted me. They moved, they got a new address, and then they didn't update the court. Then their ex filed some kind of motion in the system, in their case, and an order was granted without them even having a clue because they moved and didn't keep the court updated as to their address. A lot of times people don't do this to be malicious. They just assume that their ex is going to serve them again. But no, as I've explained in previous videos, the initial pleading is served on you personally. All other pleadings can be served on you by mail, and they most often are. Nobody wants to have to track you down. That's the most annoying part of any lawsuit, is having to track the other person down and give them the papers. The second anyone can go to NRCP5 or JCRCP5 and serve you by mail, that's what they're going to do. At least that's what they're going to do if they're an attorney. Sometimes a self-represented party will still serve their ex personally just to be obnoxious, which is something I caution against. This notifies you that the order is enforceable throughout Nevada, and I'm sure it covers other states as well. Oh wow! It actually imposes a federal. They create a federal crime out of it if you cross state lines with the intent to injure the applicant. I didn't know about that. I wonder if anyone has ever been convicted of violating an order of protection in federal court because they cross state lines. Tribal is covered. And I hear Canada's covered too. This portion here, it's just more boilerplate, really. This is just stating that a domestic master who enters one of these is exempt from the ordinary process. So ordinarily, a hearing master, cannot enter an order. They can only enter a recommendation for order. And then it goes to the district judge, and then the district judge will approve the order unless an objection was filed. If an objection to the master's recommendation was filed, please watch that video if you haven't seen it. If it was filed, then the judge will consider the objection and determine whether or not to uphold that order or that recommendation or reject it in whole or in part. But this piece of paper right here is stating that temporary orders for protection are exempt from that process. And if a domestic master enters one, it is enforceable immediately. Though it doesn't matter because the district judge signed this anyway, right here. Frances Doherty, she just retired or is going to retire very soon. All right, let's look at document number 3. This is another order, but this order doesn't impose any restrictions on me. This is just letting me know that there will be an extension hearing coming up. It's another form order. They check some boxes, fill in some blanks. So it gives me the date and time of the hearing. It lets me know that it's upon the motion of the applicant to extend the order. She didn't actually file a motion. This is just automatically done. Once the application for order of protection is filed, they just automatically set a hearing to extend it. I suppose an applicant could ask to not extend it. I suppose it's possible for an applicant to say, you know what, I don't want to extend this. I'll just take the temporary order for a month and I'm good. Maybe they're going to move to another state or something, and that'll be that. So I guess that's a possibility. Linda Gardner signs it again. This time, just the master. I don't think the district judge signs it. Yeah, there's no order from Francis Doherty on this one. So there isn't anything else to mention with regards to my mindset because I was completely ignorant that any of this was going on. There will be another video coming out after this which does cover me being served with the actual order of protection, the temporary order, as well as the notice to appear at that hearing and contest it. And in the next video, you will get a whole lot of details as to how that went about, how I was served, what I felt, and how I reacted. It was an immediate reaction by me to try to have that order dissolved. The aftermath is going to be very uninteresting in this video. My ex incurred $0 in costs. She didn't have an attorney, so she incurred $0 in attorney's fees. I, of course, wasn't involved in this process at all, so there's no way that I would have incurred any costs or attorney's fees. So this is basically going to be the end of this video. Not a very long video, but if you have any questions or comments, definitely post them down in the comments below, and you'll be hearing a whole lot more about this as we continue on in the series. And it's going to get really, really messy, especially because the first time that I have to actually appear in court against my ex, she is going to have an attorney at the hearing and I am not.